Hello, this is Matt on the Moon Lambeau channel. The SEC's behavior in the SEC vs. Ripple case is becoming increasingly bizarre, resulting in attorney Jeremy Hogan noting, and I quote, "This is not normal," end quote. I put out a video a few days ago where I was highlighting that the SEC is now actually arguing two completely contradictory positions simultaneously. It's bizarre. And I've been looking forward to Ripple's response to that, which was filed today. So I'll be sharing that with you, along with some comments from attorney Jeremy Hogan. But before going further, I do want to be clear that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, let me set the table properly, and I'll try to be brief because I know that some of you are caught up to speed, but I gotta go through this or else the story's not going to make sense. So here's a headline. This is a new headline from just this afternoon from Finance Feeds. And this is titled, "Ripple CTO Chokes on Diet Coke as SEC Desperately Tries to Overturn Court Ruling." The SEC said Bill Hinman's speech was his personal opinion. He signed an affidavit stating just that. The court accepted that as the truth, which makes documents pertaining to that speech unprivileged information. The SEC, however, seems to be doing a full 180. Oh, yes, they do. The Securities and Exchange Commission has asked Judge Annalisa Torres to wait until February 17th, 2022, as the plaintiff prepares a motion for partial reconsideration of the deliberative process privilege ruling ordered by Judge Sarah Netberg. So some of you may be aware at this point that that was a major ruling we were waiting on. It was on the topic of which documents that the SEC has are truly privileged and Ripple should not have, and which are not privileged and Ripple should have. And it was kind of a mixed bag. Most attorneys that I read opinions from seem to think that the ruling was a little bit better for the SEC than Ripple. But Ripple did get some stuff out of it, including, they're supposed to anyway, get documents having to do with Bill Hinman's Ethereum free pass speech from June 14th, 2018. So yes, again, a little bit of a mixed bag, but that part's good because, again, that speech is just Bill Hinman's personal opinion, right? That's what the judge found. So the documents are unprivileged. SEC's not so happy with this, so check this out. The SEC wants to file a 20-page brief and submit more documents for the in-camera review in support of the motion to reconsider the court's ruling of one single aspect of the order: the drafts and emails in connection with ex-SEC Director Bill Hinman's speech, June 14, 2018. And XRP community member and attorney James K. Filan noted that, quote, "The SEC is desperately trying not to have to turn over the documents to Ripple." That's a quote. And so you just got to kind of ask, why is it the case that the SEC is fighting so hard to avoid having to share this information? And then Ripple CTO and co-creator of the XRP ledger, David Schwartz, wrote the following on this topic. He wrote, "I choked on my Diet Coke as I read this." And what was he reading? Well, here's the short 1 or 2 sentence snippet right here. Take a look at this. This is absolutely absurd. This is the part where the SEC is now officially, simultaneously, arguing two different positions that are at odds against one another. It's really bizarre behavior. And it reads as follows. This is from the SEC attorneys. "The SEC respectfully submits that these additional documents clarify the truly deliberative nature of the discussions surrounding the speech across the SEC and show that the speech was not merely peripheral to actual policy formulation, but was in fact an essential link in the SEC's deliberative process with respect to Ether and other digital assets." So, be clear, we're talking about Billy Hinman's Ethereum free pass speech right there. This does mean that the SEC is arguing that that the speech is just Bill Hinman's personal opinion, but they're also arguing now that it's an essential link in the SEC's deliberative process privilege, meaning that it's supposed to be secret. So they're arguing both. They're arguing that it's just Bill Hinman's position, but it's also the SEC's position, because or at least that it's part of their deliberative process, making it privileged. These two positions are contradictory, but they're simultaneously arguing both of them. Truly bizarre behavior. And so Attorney James Filan shared Ripple's response today and wrote the following. Ripple defendants have filed an objection to the SEC's request for additional time to file a motion for reconsideration of Judge Netburn's DPP ruling. Now, I'm going to run through this, but first, for fun, I thought it would be a good old time to share perspective from Attorney Jeremy Hogan on this first, and then we'll go through the specifics. And so here, in a tweet from Jeremy Hogan, referencing Ripple's legal filing from today, he's noting that Matthew Solomon, one of Ripple's attorneys, is on point, and he's, again, at least one of the people that filed this, right? Here's one. I don't know how many filed this, not that it particularly matters. Yeah, there you go. So anyway, he's listed right there. So here's what Attorney Jeremy Hogan had to say about this. Attorney Solomon is on point as usual. It's a head-scratcher from the SEC, as it's fairly obvious that the motion probably won't be granted, and surely not won, even if granted. And the SEC then goes on to contradict its own position on the DPP privilege. This is not normal. It's not normal though, right? I mean, I don't have any sort of legal background, but this is freaking wacky. This is Looney Tunes, okay? Like, these SEC attorneys are cuckoo for Cocoa Puffs. This does not make any damn sense. And then somebody asked Jeremy Hogan the following. What does your attorney sense tell you, Jeremy? Have you seen something similar before? Jeremy Hogan said, my instinct is that someone higher up the food chain got involved and instructed the lawyer to fight the DPP loss harder or to go scorched earth on the litigation, i.e. delay, increase Ripple's costs, etc. I've seen things like this before, yes. So it's not normal, but he's seen it before. Freaking SEC, man. Talk about asshats. And then somebody else wrote to Jeremy Hogan and said, you're literally using probably won't, the term probably won't, because the judges have been consistent in giving the SEC a wide berth to throw their tantrums. This case causes me to give a vote of no confidence in our criminal justice system in its most important role, that of reigning in government. And so Jeremy Hogan wrote back to that and said that's exactly correct. The judges haven't been exactly hammer judges thus far, and so I leave a little wiggle room in there. Yeah, well, I'm not thrilled with some of this and the delays and all that, just in a general sense. But I do think that most of this pre-trial stuff, it's actually been in favor of Ripple, so I just think you're not going to get everything that you want, so I'm not going to go quite as far. I respect the perspective. I just don't feel quite the same. I don't think that this is some sort of indication that the justice system doesn't work. That's my personal humble opinion. Anybody feels different, that's perfectly fine. I just don't think we're there yet. Now, this thing could go absolutely horrible, in which case I'll be talking about that, but we're not there yet. And so here's the actual legal filing from today from Ripple. Dear Judge Netburn, on behalf of Bradley Garlinghouse, Chris Larson, and Ripple Labs, Inc., defendants, we write in opposition to the SEC's request for an extension of time to file more documents attached to an oversized motion for partial reconsideration of the court's January 13th, 2022 order. The SEC requests, number one, 4 weeks to file its motion for reconsideration, where Local Rule 6.3 provides for 2. And point number 2 here, leave to file another 20-page brief, where court practices allow only 5, and point number 3, leave to submit approximately 66 more documents to the court for in-camera inspection that could have been provided by the SEC prior to the court's already extensive review, and the SEC now claims supports a new argument. And so, just to pause, the judge already did review all these documents, these allegedly privileged documents, in person. So when they say in camera, that just is another term for in person. And now they're saying that they got all these other documents. Well, why the hell didn't these asshats at the SEC provide all of it in one go? Now they're saying, wait, hold on, you already made your ruling, we don't really like it, so here's a bunch more documents, please change your opinion. That's what it looks like, right? That's what they're doing. It's completely absurd, all right? Anyway, Ripple's attorney continues here. The SEC's attempt to inject delay and re-argue its position based on additional materials and arguments is improper. And then they provide some sort of precedent indicating this, and here's a quote from whatever that case is, some CRM Holdings Ltd. Reconsideration is not an invitation for parties to treat the court's initial decision as the opening of a dialogue in which that party may then use such a motion to advance new theories or adduce new evidence in response to the court's rulings. And so there, but pause. That's what the SEC is doing, isn't it? They don't like what the judge had to say, because that means that the Billy Hinman speech and all anything that's included in there, it's going to be, all those documents are fair game for Ripple now. They don't like that, and so now they're basically just trying to have this decision thought through again. It's just a Hail Mary is what it looks like, and it's the SEC being a bunch of little baby back biatches because they're asshats. Anyway, continues. Defendants have sought the documents covered by the court's order for almost a year. In the meantime, fact discovery has passed. 17 fact witnesses have been deposed, and expert reports have been filed. As this case approaches a new phase of motions practice, defendants are entitled to review these documents to prepare their defenses to the SEC's claims. Any further delay to allow the SEC to present new or additional evidence, or to raise new arguments that are plainly not appropriate on a motion for reconsideration, would only prejudice defendants. The SEC has had plenty of time and opportunity to put before the court whatever arguments or documents it wished. The SEC already filed declarations in support of its privilege assertions that this court already considered, in addition to substantial briefing and oral argument. Nothing the SEC proposes to submit now is new or intervening. Nor does the SEC seem to assert that the court overlooked important matters or controlling decisions that might reasonably be expected to alter the conclusion reached by the court. Instead, the SEC apparently seeks to re-argument on the basis of dozens of self-selected documents it logged months before the court issued its January 13th, 2022 order. This is so, folks, this is so clearly, plainly, obviously the case, right? The SEC, they're not being genuine. They're being intellectually dishonest, right? Because they're not stupid. They're just not being good people, right? The judge isn't going to fall for this, right? Anyway, lawyer continues. What's more, the SEC apparently intends to argue, contrary to its repeated assertions and sworn statements, that Director Bill Hinman's June 2018 speech represented only his personal views. Keyword there, only his personal views, right? And again, we know now that saying, oh, it's his personal views, and in addition to that, it's also part of the SEC's deliberative process, so it's all privileged. Completely contradictory positions. It's completely absurd. Anyway, Attorney Solomon continues, that Entry 9 of Appendix A and similar documents were an essential link in the SEC's deliberative process with respect to Ether and other digital assets. This is a reversal of the SEC's litigation position to date. Before the court's order, the SEC argued that these documents were protected by the deliberative process privilege because they reflected internal agency communications on what Director Hinman's June 2018 speech should say, despite having the opportunity to argue its prior briefing and argument that Entry 9 and similar documents related to agency deliberations about the regulation of Ether or digital assets more broadly, it did not. It cannot do so now. And then he wraps up by stating, the SEC should not benefit from its wait-and-see approach to continue delaying the production of potentially exculpatory documents defendants have been seeking for the better part of a year. The local rules and the court's practices prescribe ample time and space for the SEC to articulate its position on the single aspect of the court's order that it intends to challenge. The motion should be denied. That's it. So I like the phrase it's been used here. Maybe Jeremy Hogan got it going, but Attorney Solomon here, spitting fire. I like it. I definitely like it. And I've been really looking forward to seeing the response, and it's what you'd expect. So knocking it out of the bargain. It's just a question of like, how's the judge going to respond to all this? So we shall see, but it just keeps getting more and more bizarre. Really grinds my gears, folks. Really grinds my gears. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.